Hello, everybody. As Helen's just described, I'm Alex Stewart. This is Karen, or Dr. Karen Mungie, who happens to have worked in hospitals, and I think most of you will have come from the hospital environment. We're just going to check. Okay, so as many of you know, I've previously worked as hospital lawyer, and now I work in the university, and we often deal with collaboration agreements. Oh, sorry. There we go. And today we're going to talk about intellectual property tips and tricks. Before we do, I think I've jumped a slide in terms of our acknowledgement of country. QUT acknowledges First Nation owners and the lands where we gather today, pay respect to elders, laws, customs, and creation spirits of the country. We recognise these lands have always been a place of teaching, research, and learning, and we acknowledge the important role that Aboriginal and Torres Strait Islander people play within the QUT community. So, intellectual property tips and tricks, it's quite a broad measure. So let's talk about what we're actually going to be trying to look at today. And here we're going to be mainly looking at the interaction when there's a university and a hospital doing some form of clinical research. There'll usually be a clinical research agreement which happens between them. And in that clinical research agreement, there will usually be a clause that talks about background IP, and a clause that talks about project IP, and maybe even a clause that talks about future licensing. So we're going to go over some of the principles that you should consider when you're completing one of these documents. And we're going to take it to quite a high level and look at it from policy and then theory and then go through practical examples. What we're not going to do today is talk necessarily about clinical trials. We're not going to talk about commercialization directly, and we're not going to talk about moral rights. Those are things that are going to come up in later seminars. So, what is the right answer to what you should put down in terms of IP ownership? I'm a solicitor for QUT. I'm incredibly biased in that regard, and I'm definitely going to tell you to always put down QUT, even if QUT is not a party to the contract. But if I take my biased hat off and try and look at it in a reasoned way, then I would suggest that there's probably two questions that you should be asking. And that first question is, what would ownership of the IP be like if there was no contract? And once we've figured out what that ownership position would be like, we can then have a few thoughts about why we would want to change it from that position. Because merely by entering into a contract, we do potentially change the position which would exist at law. Now, there are various types of clinical research contracts which are around the place. A lot of my comments goes to the Research Passport Agreement, version 3.2, which is the current HTQ agreement. There's also the DOH Clinical Services Agreement or Clinical Research Agreement, which is for non-clinical trials. And we've also got things like the NHMRC MIA and the ARC linkage, which is often used for clinical studies. So we've got a broad variety of different agreements which can be used, but I'm mainly going to pivot towards the HTQ one for this presentation. So today I'm going to talk about theory and policy, why we've got IP. I'm going to talk about some of the special requirements of different types of IP, and I'll talk to confidential information and copyright, and Karen will talk to patent. And then at the end, we'll have some specialized statements of tips and tricks as they relate to the HTQ agreement. So, what is intellectual property? It's a big term, it's a colloquial term, it doesn't have a proper legal meaning. About the best form of legal meaning that you'll ever find happens in the World Intellectual Property Organization Treaty at Article 2, which gives that definition. It says rights relating to certain works of a literary, artistic, scientific nature, scientific discoveries, industrial designs, and a few other odd ones like protection against unfair competition, etc. So it doesn't really give us much insight into what is IP. I would simplify it down to this definition. I think that's probably the best way to think about it at a very high level, which is that intellectual property is a grab bag of rights about things created by thinking. It's got the clue in the name. It's intellectual property, things from the mind. Now, all definitions in contracts are relevant and important because they define what you're talking about. And in the HTQ one, we've got this definition. As some of you may see from that, it's not necessarily things which are all from the mind. It's not necessarily things which are all protectable. It's a definition created by committee. I can't say that I'm the author of this one. It is the same definition used by IP Australia in their commercial arrangements, in fact, through a lot of the Commonwealth arrangements. But it's not, and it's also used in the Department of Health's Clinical Research Agreement. It's different to what you would find in the NHMRC agreement. It's different to what you'd probably find in an ARC linkage agreement. Most importantly, you'll see the differences would be where we've included moral rights within the definition of IP. Domain names wouldn't usually fit in there. And trade secrets and know-how generally wouldn't be within that definition either. And we'll have a talk about why they are in there, or at least why know-how and trade secrets are in there as we proceed. So I guess before we talk about what we should do with IP and what is IP and identifying IP and all those sort of things, we should talk about why we have IP laws at all, or even the bigger question of why do we have laws at all. Some people think it's common behaviour, people think it's for a particular result. For our purposes, IP is really an economic matter. IPs shouldn't really exist. It slows down the use of technology and access to new technologies. You get infringement notices which prevent you from making use of, say, a clinical discovery in the future. If someone's got a patent over it, you can't use it. You can't get your mate down at the local mechanics shop to make you a copy of the best bone saw or the best surgical tool, which you could use in a healthcare practice. You can't get free access to software because of IP rights, which prevent this all. In fact, IP generally and is understood to create economic hindrance to people in terms of access to new IP, in terms of access to new results of intellectual effort. And the law generally doesn't favour that kind of economic hindrance. As far back as the 16th century in Darcy and Allen, patents given for playing cards were seen to be problematic because they increased the cost to everyone of accessing playing cards. And the same can be said of new technology. In fact, there are quite a few legal and economic scholars these days who say IP really shouldn't exist in the modern environment. It's problematic and it slows down the use of things. It effectively prevents us from having a more and better technological world. That's what some lawyers and economists think. The basic theory, though, is this. In order to innovate, in order to do new research, in order to develop new products, you have to put in time, effort, and you have to spend money. If everyone could use the results of that activity freely, then other people would. They might make those products better. They might put those products onto the market. They might defeat the original person who came up with the idea. And knowing this, a person who could come up with ideas, who could make that expenditure, would have no incentive to make that innovation. As a policy, government, the Crown, thinks that innovation is a good thing. It wants to promote innovation. It wants to promote dynamic efficiency within the economy. So therefore, at a policy level, legal rights are granted to creators so that they can be assured that they'll be able to make some use of their intellectual property in the future. So that policy results in certain types of rights, and those rights are things which protect substance. They protect things that can be adequately described. They can't just give legal rights to something like playing cards, which are already known. It's got to be something that's new, and it's got to be something which is of benefit or utility in relation to inventions, at least. Protection's only given for a small amount of time. After that, it's a free-for-all. Once a drug's out of patent, anyone can manufacture it. Once a work is out of copyright, it can be printed by anyone. Protections given to employers because this is an economic form of property, or it's created out of an economic policy. Of course, it's going to go to employers, and because it's a form of property, it can be licensed, owned, transferred, and used in that manner. The real fundamental heart of intellectual property, though, is this idea of exclusive rights. The person who owns the intellectual property owns the legal rights to do a certain thing and may sue anyone else for infringement. They may exclude them from making use of the intellectual property. So those exclusive rights are given for a limited period of time. When it's over, anyone can do it. So when we talk about a generic drug or something of that nature, then that's exactly what it is. The patent rights have run out and anyone can make use of that in the future or manufacture it into the future. So I mentioned before this issue of ownership and licensing, and I think this is a pretty useful guide for you. Ownership is obviously being that person who controls the IP, who can make decisions about it, who can exercise those property rights. But license is just as important, and in some contexts, more important in relation to research. But a license is a contractual thing. So if we imagine that there's no contract in place, which is sort of where I was coming from before, and we've got one person that says, I'm the owner of this IP and I grant you a license to make use of that IP, then the law will kick in and say that there are a bunch of default terms which will allow us to understand what that license means. Now, most contractual licenses, and you'll see in the passport agreement, they include explicit statements about these things. But if there's no statement, if it's just a license, then we would expect that the bolded nature of the license here would be the one that would apply. So it would be non-exclusive. A person who gets just a license in IP can expect that that owner will also grant licenses to other people. Unless they stipulate that there's a fee, you'd expect it would be free, or a royalty, you'd expect it to be free. If they don't say that it's just in Australia, then you can expect it will be around the world. If they don't put a time limit on it, you can expect that it would be anywhere. You'd expect the license to kick in straight away from the point of time that they grant it, and that you could use it for any purpose unless they limited it in that way. But you would also expect that you couldn't sub-license it or give that right to someone else, nor could you transfer that right to someone else without some explicit statement in relation to that. The one that is sort of the odd one out of all these license terms is the revocable, irrevocable, and bare license nature. And that's really important because if you don't give consideration for your IP licenses, then the person who's granted it can potentially just revoke it immediately the moment after. So consideration in contract is quite important when we come to doing licensing. So that's the general idea of how intellectual property works. But each type of intellectual property has its own little special measures and its own little special nature. And I'm going to go through two of those now, one of which probably arguably isn't even a form of intellectual property, and another which definitely is. So the first is confidential information. Confidential information is highly important in research. It's that fundamental basis on which a collaboration is performed. And it's also the place from which a lot of intellectual property is drawn. However, there is some debate amongst lawyers about whether confidential information does fall within the grab bag of intellectual property, and certainly whilst it's included in the HTQ one through the description of trade secrets and know-how, I think the debate is probably moving towards confidential information not being IP, and I'm going to explain some reasons why that is. Often, though, people lose sight of the fact that there's no legal definition necessarily of what is confidential information. Lawyers, when they talk about confidential information, are actually subject and based on the point of talking about a breach of confidence rather than anything in property. This is the definition from Justice Gummo, which I actually think is probably the best definition and the most useful definition for a breach of confidentiality. So it's very simple in that information must be specific. It has to be something which is articulated. It can't just be, I had an idea that A, B, C, and D. It's got to be literally what is that idea? What is that information in a way that can be described with specificity? The information has to be something that would be secret. And here, confidential information covers a lot of things, everything from photos of exes or photos of someone else through to secret plans and secret documents or secret prototypes. The information confidentiality and confidential information only really kicks in when that information is handed over to another party, and that's when the obligations come about. But that other party has to know that the information is secret or reasonably ought to know that the information is given under an obligation of secrecy. If it's just given away as sort of free information between two parties, then confidentiality might not kick in. And then there must be some actual threatened misuse in order to create the breach. So some of the differences between confidential information and ordinary IP: confidential information can't be assigned. You can't transfer those rights in a sense. You can create new confidentiality obligations. So someone who's imparted confidential information can then sign into an agreement with a third party to say, I'll let you have that information, you can do whatever you want with it, and I agree to be bound to confidentiality in respect of it. But that's quite different than an assignment. It can't really be licensed. You can't grant someone a right to make use of confidential information the same way as a license, but you can give them a right to further disclosure in specific circumstances. And of course, confidentiality is destroyed once it becomes well known, i.e. when it goes into a publication. So you'll have seen from the HTQ definition that know-how is included in there. And I think that know-how is a vital issue of importance to understand for medical research, and is actually sometimes poorly understood in the field of clinical research. So know-how is something which potentially might always rest with the person who knows how to do something. Now, you might reduce your know-how down to a written example or a written set of plans, and that written set of plans might have IP in it. But it doesn't mean that you can necessarily prevent or restrain the employee who's got that know-how from continuing to make use of it in the future. In the law, we have this doctrine of the unreasonable restraint of trade, which will get involved and prevent know-how from being constrained in a particular individual. So as an example, say that you've got a medical practitioner, he has done a clinical study and has learnt a bunch of stuff about a particular condition or a particular set of treatment. If it is the case that a university or the hospital tries to get them to sign an IP assignment and says you can't use that know-how in the future, as it does in, say, the HTQ agreement, then the law will potentially kick in and make that requirement to restrain that individual employee or health practitioner invalid. Accordingly, so when we're going through, and this is sort of the first tip, when we're going through and filling out these schedules, we have to be aware of the potential that we're not actually binding parties in relation to specific knowledge. And if that is the intention of the institutional parties, they've got to take other steps to get around it. So that's confidential information, which is probably not a form of IP. Copyright, on the other hand, is most definitely a form of IP. And it is a form of IP which rests in things which are printed down, reduced to material form, like documents, drawings. A computer program is potentially IP. Forms, buildings even can potentially be IP. Artistic works, but also subject matter which can have copyright in it may include voice recordings, video recordings, etc. It's potentially everywhere. And what it really is the exclusive right to do certain things with a particular work. The nature of that right is varied between copyright and original works, and even between artistic works and other literary, dramatic, or musical works. And it's also varied as to in relation to subject matter in which copyright may exist. Generally, though, the rights are what you'd expect. They're the right to make a copy. It is the right to copy. It can also include the right to publish, the right to perform, the right to communicate to the public, the right to make an adaptation or a derivative of the work. And it's things of that nature. It's really about copying or transferring or changing the form of a particular work, which is protected by copyright. The protection's automatic. You don't have to register it. It just kicks in as a result of the law if it's from an author, if it's original, if it's in a material form, and it fits all of those other elements under the Copyright Act, then legal rights are automatically granted. And it goes for a long time too. I'm pretty sure that when MS-DOS finally comes out of copyright in 2050, we're all going to be happily going and making use of that computer program. So going back to our original idea, who is going to own this stuff if there's no contract in place? The first port of call for copyright ownership is the authors. That's where we start our detective journey if we're trying to figure out who is going to be the owner of something. However, I will note, as we have done in relation to all IP, the role of employers is very important. So that's Section 35(6) of the Copyright Act, which effectively provides that if it was done in pursuance of the terms of his or her employment, then the copyright will belong to the employer. It does, however, kick over an important step because, firstly, the terms of employment might provide for various rights for the copyright to remain with the authors. Also, in relation to HDR students, I would point out that those students are not employees. So unless there's some kind of student IP deed there, then you might not potentially own what you think you're owning when you're writing the contract. My tip, and I've done this in red just to make sure that everyone knows it, is, are your authors all bound up? Certainly people should go through and figure that out before they start dealing with the IP. I think I want to cover this issue as well because it is incredibly relevant to clinical research agreements. And that is the issue of copyright in data and whether there is a form of intellectual property that covers data. And the reason is that in clinical research, we end up doing a lot of collection of data sets, whether that's from sensors or through other means. We often are worried about trading these things off in clinical research agreements. I would say there's not probably that much to worry about. A whole bunch of cases like ICE TV and the telecom cases, telephone book cases, set out that that requirement for originality for having come from a human author is absolutely necessary. So if you've got a clinical database which has all of the ECG readings of a bunch of patients that have come through, there might be copyright in how that, in the form in which that's presented, in accordance with the William Hill sort of approach. But the actual data itself, each one of those individual records which have come from the sensor data, probably doesn't have originality. And certainly Justice Perham in the Federal Court of Appeal, took the view that without that originality, you're not necessarily going to have an author and you're not necessarily going to have a copyright. Implications for us is that, well, a lot of medical records are probably not copyright materials. Where I think there should be some caution about this is if a medical record includes someone having written down an opinion, and that creates a whole different set of problems, particularly around doctor or healthcare worker and patient relations, which are all set out in Breen and Williams, amongst other cases. But I'll move on to copyright co-ownership. And the reason why I do this is that you might have seen the standard position in the Research Passport Agreement is about co-ownership. Effectively, it says a copyright co-owner. Effectively, it says if nothing is written down around ownership of IP in the schedule, then we'll be in a position of co-ownership. And co-ownership is a bit of a dangerous position for copyright. And the reason is this part, which is Section 36 of the Act. And it says, look, if you don't have the permission of all the owners of the copyright, then you will infringe the copyright if you make use of it without that further license. Now, the way that's interpreted in the law is that a co-owner of copyright, even if they've got that ownership interest, will infringe if they don't have the license of their other co-owners to make some particular use of it. And that might be in an academic paper, or it might be for software or code. It might be reproducing that software or code or using it in a computer system. Accordingly, you have to always make sure that you've got some cross-licensing position if you are entering into co-ownership for copyright. The position is different with respect to patents. So now we've learned about the three main types of IP, or what could be called IP, that you're probably going to run across in clinical research. I'm going to circle back to what do you do if you fill out the HTQ agreement, and what should you know? Because we've talked about lots of different issues like ownership and contractual assignment and license, and they are very relevant to this. So starting with background IP, this is the definition which is contained in the HTQ agreement. And you'll see that there's quite a lot there. There's 4 different types of things that can go in. And that includes things which are of secret nature, which are created before the agreement and handed over to the project. It could be created independently of the project and transferred in. It can be specifically listed in the project schedule, or it can be the improvements. And so that goes through the 4. So having a look at those, I'd like to bring up 2 points just to your attention. And that is that, yes, background IP can be drawn in specifically. You don't have to list it in the project schedule. But my tip would be, if possible, if you know that you're contributing some background IP, specify it. And one of the reasons for that is that not only can you specify it, you can also specify particular encumbrances or particular obligations in relation to that particular bit of background IP, without specifying it in the project schedule, in that item in the schedule, people get a pretty free run at it, and they also get a right to negotiate a future commercialization license if it's necessary in order to commercialize the project material. Accordingly, you're binding yourself up to something which is potentially problematic for your future management of the material that you've already handed in. The other thing that I'll bring your attention to is improvements. Now, improvements are sort of a bit of controversy in IP land, because you create this position where someone might give a bit of background IP to a project, and then the other parties go and do some great improvement to it, but it gets assigned back to the original party who brought in the background IP that's been improved. That can be very unfair, especially if the intellectual grunt work during a project is done by the party who didn't originally contribute the background IP. Accordingly, tips. First tip, figure out what the background IP is that you're providing to a project. Do an audit, do an inventory, get someone to write it down, do some due diligence, figure out who owns it, figure out whether you've even got the rights to use it if you've got it on a license which is less than full ownership. And then I would suggest this, in fact, I advise this to any project that's running. Always keep for your side, for your institution, a register of all the background IP that's being used in the project. I think that's probably one of the best things that researchers can do in order to make sure that the IP determination down the track is done easily. I would weigh up whether you want to give the improvements right to another party in a HTQ agreement every single time, and figure out whether that's going to be a fair position to get into by signing the agreement. And thirdly, look, if you don't have the full ownership of background IP, but someone still wants to supply it, set out what rights you do have. See if it's open source, see if all the parties can get their own open source license, etc. But be clear, because otherwise you could accidentally fall into a breach of contract or unintentionally infringe the IP. So project IP, this is really the main game. And as I said, because I work for QUT, I'll always say project IP should be owned by QUT. But if not, step one, figure out who would be the owner without the contract. Who are the authors? Who are the inventors? Who are likely to be the inventors? Is everyone bound by IP deeds? Is everyone bound by employment agreements? You know, and as we say from UWA and Gray, is the work being done in pursuance of the terms of employment of the people who are doing the research? Figure out what that all is and figure out where you would be if there was no contract. Then have a look at the item and figure out whose name should go in there. Should it be a change from the regular co-ownership position in the HTQ agreement? Or are there particular expected outcomes where one party should own one particular bit of the IP? Will the parties have to register? Registration is an expensive process. If they are going to have to register IP rights like a patent, figure out who should be the owner and who's going to be in the best position to make use of it. Figure out whether improvements should actually be project IP and should be dealt with it under that. Figure out what sort of licensing you've got to have. And of course, in the next session, you can figure out whether commercialization is going to play a role in who should be the owner. But that main step two, is figure out where you want to end up rather than where you would be if there was no contract in place. So this is my sort of final note on it. I've worked in research for 10, 15 years. I've worked as an IP lawyer for 20. And I'm constantly aware of the worst possible outcome from the expenditure of money on clinical research, which is that there would be a discovery made that it would sit on a dusty library shelf and not actually picked up because no one's clear about who owns the IP. There's no imperative towards development or future commercialization, or it's just becomes too hard because there's too many disputing who would be the owner. And that happens. I've seen that happen regularly. I'm always reminded of the penicillin example, that research was done in 1928, which found penicillin by Alexander Fleming. But it wasn't until 1942 that antibiotics were formed from that penicillin when Chain Florey and Abraham picked it up later on. And that during that gap, the number of people who would have suffered without having that medicine. So, as I would say, always be aware of your IP, try and keep it to the front of mind and try and make some good decisions about it. That brings us to the end of the presentation. And you can put questions into the Zoom. I don't think we've got much time for it. There is one question already in the Zoom, which is, I think, talking to copyright, and it's about ownership of information collected from surveying participants as part of a human research project. Would those survey responses have copyright, or is it just data? I can answer that one pretty quickly, which is that it depends on what is being responded to. For instance, if it's just marking down, do like to not like, and someone's putting in their answers in, say, a 1 to 5 response form, a quantitative response form, there's probably not much copyright in each one of those examples. In qualitative studies, that can change. I do a lot of work with Indigenous groups, and we've always got the issue of, is there traditional knowledge being provided in qualitative research? Who owns that material, etc.? And in those cases, there can certainly be copyright in the responses which are written down from a survey participant. It becomes more difficult, of course, if there's a verbal response which is then reduced to writing or is reduced to a transcript. And that can become quite an involved issue. So generally, when I'm talking about research data, I'm talking about structured data per participant, which is like that 1 to 5 response or ticking the multiple choice answer. That sort of thing is definitely not going to have much copyright in it, but qualitative responses can. In terms of further questions, there's one more. If we hire someone to do research, but that person would like to use it outside of their organization, can you prevent that? That is the point of the exclusivity rights in intellectual property. If one person becomes the owner, then they will be able to exclude a third party from making use of it. More so, I would suggest that if you're hiring someone to do research, you need a strong service agreement which covers both confidentiality and articulates use of the results. So I think we have enough to end the session because we've gone to time. So there's one further one from Sarah Flame. Hello, Sarah. Ownership of medical records, does that sit with the collecting party in HTQ? I think ownership is left a little bit quiet in the HTQ agreement. I'd have to look through the particular clause. But I understand the study participant data clause is the relevant one you're looking for. And I think that we shy away from using the term ownership of all when it comes to medical records, but it's likely to be with the collecting party in there. The next info session for the HTQ series is on the 14th of September, and invites will go out through the usual way to HTQ participants. And we look forward to seeing you then. So thank you very much.